no fraud, no programming error, no claims of improper conduct, no claims of illegal conduct or any other fact whatsoever. But in that bare bones petition, consisting of one sentence and one line, taking out of the statute, they're demanding that the people of the state of Michigan spend $5 million to recount the election. And by filing this petition and making the public statements they've made without any factual basis whatsoever, they've cast aspersions on the election and why. Well, their public statements appear to be because we can. Stein received about 50,000 votes out of almost 5 million votes cast in the election. It's going to cost at least, according to estimates from the Secretary of State's office, $5 million to count these votes. If my math is correct, it's going to cost the taxpayers of the state of Michigan to tell Ms. Stein $100 for each vote that she cast, that she got 50,000 votes. Now this is relevant because Michigan election law requires a candidate to be, quote, aggrieved in order to seek a recount. That's 879 of the Michigan election law. Now, Mr. Brewer will tell you that the petition has, to file a recount petition, there are very few legal requirements. It's a real low threshold. And he's right. But this petition doesn't meet those. The first and most important threshold that has to be met is that the candidate has to be aggrieved. The petition alleges that the candidate is aggrieved. But there's no case law in Michigan election law that addresses what is defined in aggrieved. That's because the issue has never arisen. And it's never arisen because no one receiving 1% of the vote has never attempted to foist a recount, a $5 million bill on the taxpayers of the state of Michigan. It's never been litigated. All of the case law in the state of Michigan addressing recounts deals with two candidates who have been very, very close in an election. One candidate has been aggrieved because that candidate could have won an election because of the closeness of the vote. That candidate, therefore, has requested a recount because of the difference in the vote of 3, 4, 5, 10, 100 votes, or so on. That candidate is aggrieved because the possibility of the recount could have given that candidate the right to hold the office. That is aggrieved. You're not aggrieved if you want on a lark to foist the taxpayers and the elections officials to go on a wild goose chase when you have no hope of reversing the results of the election or to change the outcome whatsoever. In all of the case law where a recount has been addressed, one of the candidates has truly been aggrieved. There's no case law that addresses a candidate receiving 1% of the vote in the state of Michigan. But there are cases in the state of Michigan that do define the term aggrieved in other contexts. We cite them in our brief. One definition is a violation of a legal right that causes harm to the rights holder. How was Stein harmed? She wasn't. She isn't. She's not going to be, no harm is going to be corrected here. She's not going to gain any additional rights by a recount. She has no evidence of fraud or her position in the election is not going to be approved. Michigan law, cited in our brief, is, quote, having suffered loss or injury. In the context of an election, she would be aggrieved if she lost an election she should have won. That's why cases dealing with the spread between the candidates discuss only a few votes, not millions. Being disappointed over a result is not aggrieved. Speculating over an alleged overvote, which she did, is not being aggrieved. A possible change in the outcome of an election in favor of a candidate is concrete and verifiable, but not if the candidate received 50,000 votes out of 5 million cast. Now, other states have recognized that in their case law, that an aggrieved candidate is one who must allege the harm caused place loser is here. Now, other states, however, have allowed specifically any candidate to contest an election. They don't have the requirement that we do that a candidate must be aggrieved. We have specifically included that requirement. That requirement must mean something. Here it means that a candidate must have suffered an injury. Stein did not. She's not aggrieved in any sense of the word. This requirement is missing from her petition. Now, if you recall on Monday, Mr. Brewer read a litany of complaints alleging machine malfunctions, computer errors, hacking probabilities, tabulator mistakes, and so on. And in fact, this appeared to be possibly a basis for the board's refusal of our request that any recount be done by machine, because the ability of the machine to conduct a fair and appropriate recount was in question. But now, if we look at the petition, the recount, here's what it says. And she cites the electors individually and collectively. Of course, they have no standing. Only the candidate can claim a recount. She says, I am aggrieved on account of fraud or mistake in the canvass of the votes by the inspectors of election and or the returns made by the inspectors and or by the Board of County Canvassers and or by the Board of State Canvassers. There aren't any allegations in here of hacking, computer errors, or mistake, or fraud, or problems with the tabulators, or any of the other allegations that were made on Monday. Apparently, they've abandoned those. So if they've abandoned those, and Mr. Curtis is going to address this in more detail, then the underlying basis, the underlying objections to using a machine for common use ballots is gone. Now, the other basis, and that was the basis why Stein, through her lawyer, said, we need a recount. There's something wrong with these machines. They've been hacked. Mr. Thomas said, no, they're not really connected. Well, the computer program, somebody could have messed with those. Mr. Thomas said, no, that doesn't happen. And if they had information relating to that, they're required by law to include that in their petition. Well, it's not there. The other basis for the recount was an allegation that there's been there's a high percentage of undervotes. Well, I heard Mr. Brewer on the radio the other day, and he said, well, you know, in every election there are undervotes. Well, we looked at undervotes in the last few elections. In this election, the undervotes totaled 1.73%. In 2012, the undervotes were 1.04%. I'm sorry. The undervotes are the votes that are not counted. When you have a vote, the votes, someone's vote casts a ballot, but the ballot does not include a vote for president. And they can be explained here in Michigan. The repeated public surveys before the presidential election indicated a great deal of dissatisfaction with both presidential candidates. And people expressed an unwillingness to vote for either presidential candidate. There was a high level of involvement with candidate Sanders. And people may have written in for candidate Sanders, but he was not a certified write-in candidate. So that vote wouldn't have been counted. So that can be easily explained, and it's not out of the range of undervotes in previous elections. So that's really not a valid claim for saying that this election had irregularities. And if you look at the petition for recount, that's not listed. Of the petition states that the petition shall contain specific allegations of wrongdoing only if evidence of that wrongdoing is available to the petitioner. Now, Mr. Brewer will tell you that, well, the statute doesn't require the petitioner to make specific references. The statute only requires a person seeking a recount to make the statement that he's made in this petition. This statement, he'll tell you, is enough to cause the state of Michigan, the electoral function, to be cast into total disarray and spend $5 million. All he has to do is give this one sentence and throw it out here in front of the board. But that's not totally true. And that's not totally true because of the next sentence that says, the petition shall contain specific allegations of wrongdoing only if evidence of wrongdoing is available to the petitioner. Now, on Monday, it sure seemed that the petitioner had specific evidence of wrongdoing. They read multiple points into the record that they had evidence of wrongdoing. The machines were goofed up. The machines weren't tabulating. The machines were hacked. There was this terrible undervote. But it didn't make it into the petition. The petition could have been 5 hours after the election was certified. They waited 43 hours and some minutes after the election was certified. They delayed till the last possible second to file their petition for recount. It could have been filed in early November. They waited till the last possible second. The election law allows the other candidate 7 days to object to the petition for recount. We filed our response, which wasn't one sentence. It took them 48 hours to file one sentence. We filed our response based upon extensive legal research and analysis within 24 hours, or less than 24 hours. That delay is not caused by the Trump campaign. That delay was caused by the Stein campaign's failure to file their petition for recount on a timely basis. That was caused by the Stein campaign's gaming of the system and using every possible second to file their petition for recount, and then pointing to us using less than 1/7 of the time available to us to protect our rights and saying, you caused the delay. That's not true. That's an absolute falsehood. John? One other point. Finally, if you are to deny our objection, we would request a stay of the election until we can take an appeal.
Thank you. I believe Mr. Gordon meant a stay of the recount.
Yes, I'm
The
sorry.
election has occurred. Members of the board, John Peerage, I'm pleased to join Mr. Gordon, my longtime friend and colleague. I do agree with Mr. Gordon's arguments that the requested recount cannot go forward. Candidate Stein cannot contend that she won the vote in the state of Michigan, and it would be ludicrous to say that her vote was undercounted by over 2 million votes, which we all know was not the case. And as Mr. Gordon pointed out clearly, candidate Stein has failed to allege any improprieties that harmed her, and thus she fails to satisfy the aggrieved standard in 168.879. I'd like to focus the remainder part of the presentation on three distinct issues. Number one, to reiterate what Mr. Gordon said in regard to the November 28th statement that Mr. Brewer, on behalf of candidate Stein, submitted. There were 8 articulated areas that would be the basis for the assertion. This is not a petition for recount. This is a statement. If you go to the second page, under item number 8, he said, attached to the petition will be exhibits from several experts in computer technology which supports the claim made in this petition. Well, I picked up the petition again, and there's absolutely nothing in the petition from computer experts or from people with experts in technology which would support the claims made in this petition. In fact, the only evidence in this record are 2 affidavits, that one of them came from me and one of them came from Mr. Gordon's colleague, Mr. Hanselman, who have actually conducted substantially large recounts in the state of Michigan and expressed what happened in those recounts. My partner, Andrea Hansen, was reminding me this morning as we were coming over here that when we did the Dave Bing recount in the city of Detroit in 2010, we finished on December 23rd. We didn't take vacations. We didn't have long breaks. We started early in the morning. We went late at night. We were stuck on a pavilion in Belle Isle, and it went on for days and days and days. And as my affidavit points out, and as Mr. Hanselman's affidavit points out in regard to the 2006 election that had over 200,000 votes cast, it took over 22 days to complete the recount. Now, with all due deference and respect to my friend Mr. Thomas and his staff, who have been saying hand recount when we had local officials, we had state officials from the Bureau of Elections, we had attorneys, we had all of it. But we weren't recounting the state of Michigan. And it is an arduous, difficult process, bringing transfer cases from throughout the county to a centralized location, maintaining security, getting sufficient workers available, working for long hours, doing tedious, mind-numbing hand recounts. To think that we can do 5 million ballots between now and December 13th, and that's not an artificial date that we came up with. Because if you look at 5 U.S.C. Section 5, federal law mandates that a state must determine its electors 6 days before the time fixed for the meeting of the electors. In this year, that date is December 19th. Additionally, the state of Michigan has enacted a provision, MCL 168.46, that talks about certification of presidential electors. As soon as practicable after the State Board of Canvassers has by the official canvass ascertained the results of an election as to electors of President and Vice President of the United States. In fact, if you would go back to 2000, Bush versus Gore, the United States Supreme Court issued its decision on the last date permitted for the electors of the state of Florida to be certified so that they could vote in the Electoral College. So any controversy or contest that's designed to lead to a conclusive selector of electors must be completed, in this case, by December 19th, and the certification must be by December 13th. Again, as Mr. Gordon said, this petition under the Santia case, Mr. Gordon was one of the lawyers from the state of Michigan in that case, this petition could have been filed at any time. My own experience with filing recount petitions is to file them as soon as possible. As soon as possible. Not wait until the last day after coming to this board on November 28th and waiting until after 1 o'clock on Wednesday to file. That's not what the statute envisioned. The statute and the courts have said you can file that petition so that you can expedite it. And again, a statewide recount is different than doing a House of Representative race. It's different than doing a judge's race. Some of the members of the staff and the board will recall we had a recount in the congressional race in 2000 involving Congressman-elect Rogers and candidate Byron. We recounted in 5 counties. It was an arduous task under the best of circumstances. We finished after Bush versus Gore was decided, not within the federal guideline for presidential electors because of the massive amount of time and work that was necessary. In fact, we even cited in our pleadings a Michigan Law Review article that said it's doubtful that any state could complete procedures considering the safe harbor date, especially when you impose a hand recount requirement. Here, any attempt at hand recount with these incredibly limited times available would be a helter-skelter recount, and it would violate the principle that statutes controlling the manner in which elections are conducted be construed as far as possible in a way mistakes are going to occur in this kind of a recount with the time constraints, with the resources, and the volume that's involved. So plainly, we need a harmonious reading of 5 U.S.C. 5, the safe harbor requirement, and of Michigan compiled law 16847. I read some of the reports that you have about some of the statements that some of the local clerks have made referring to such a requirement to be hellacious, to be mind-boggling, to be Herculean, to quote what I said last Monday when we appeared before you. So it's clear that candidate Stein has not suffered, that a hand recount of this nature would be a pointless expenditure and that cannot be completed in time. And if we don't complete it in time, citizens of the state of Michigan are jeopardized that their vote will not be counted in the Electoral College. That is unfathomable, completely unfathomable. Lastly, we also brought one other point to the attention, and I know that there's going to be disagreement on this point, but we brought up the fact that the petition was not properly signed and sworn to pursuant to the requirements of the It says, and by the way, it's not permissive. It says a notary shall use a jurat certificate in substantially the following form and notarizing a signature or mark on an affidavit or other sworn or affirmed written declaration. Clearly doesn't meet that standard. And when we received objections late last evening from candidate Stein, they said the following. They said, that requirement is not imposed here, and they attached a new affidavit, which is after the statutory deadline to petition for the recount. And guess what? The new affidavit comports with the Commonwealth of Massachusetts standard. So clearly this is a recognition, a tacit acknowledgement that the notarization was not correct, the jurat did not satisfy the mandatory language. And for that reason, we believe the petition should also be disqualified. I want to make 2 final points. In regard to the assertion about all of the things that purportedly, theoretically, and possibly went wrong, There's been no reference whatsoever to the fact that the Department of State has promulgated extensive rules with regard to the enforcement of the Michigan election law. And in regard to electronic voting systems, those rules were also supplemented by test procedure manuals for optical scan voting systems and automark voting assist terminals. I mean, look at this. 45 pages of standards for how to prepare the electronic voting machinery that's used with optical scan equipment. And interestingly, near the very end of this publication is what the Department of State has suggested, that a public notice be given in townships and cities and villages of a public accuracy test for elections. The public's invited in. Watch the clerks prepare the test decks. Look at them. Run them through. Make sure that they're accurate. Make sure they're precise. And then seal everything until the election workers unseal the equipment on the morning of the election. And then reseal them afterwards. So here we have these incredibly detailed standards and procedures for how we use electronic voting counting tabulators in the state of Michigan. And what are we told in this petition? We're told that there's going to be exhibits from several computer experts in technology that are going to support claims. And we see nothing. Absolutely nothing. Lastly, and I appreciate your patience, and Mr. Gordon appreciates your patience, the costs of a hand recount are extraordinarily uncertain. From last Monday, we started at $700,000. By Monday evening, it was $900,000. By Tuesday, it was $2 million. I hear $5 million. Do I hear $10 million? Do I hear $12 million? Because none of us know, but I do know one thing, that there are serious claims by to collect the unreimbursed costs for this frivolous, helter-skelter, unnecessary, and absolutely unsupported request for recount. Number two, there are less measurable but no less real costs. We've talked a little bit about them. Security, meals, overtime, Saturday and Sunday. You think local clerks, local workers are going to say, oh, sure, I've got nothing better to come in early December and spend 7, 8, 10, 12 days sitting in a room recounting ballots when there's absolutely no likelihood of any change in the outcome of the election for the candidate who petitioned for the recount. Thirdly, even if we went through all of that, and this has not been mentioned today, even if we went that into higher recount, at the end of the local recount, we get to have challenges. And then after the challenges are made, we get to appeal to the State Bureau representative who's there. And if we don't like that, we get to come back before you. We'll be here in February if that were the case. Because it could go on and on and on. We want to thank you for your consideration of our presentation, of our request, and we respectfully request that you deny the petition, that in the fact that it does not satisfy the statutory standards, and it would be an incredible waste of the time and resources of the state of Michigan to chase a frivolity. Thank you very much. Any questions, Mr. Gordon or myself?
Is there any questions from the board? None. Thank you very much.
Thank you.
This time I'd like to call up Mr. Mark Brewer. And Mr. Brewer, may I remind you, as I did the gentleman before, if you may please spell and say your first and last name for the record. Thank you.
Law firm of Goodman Acker, and I am Michigan legal counsel for Dr. Jill Stein in this matter of the recount. Madam Chair, I'd like to indicate before I get started that I'm here most immediately to address the objections. But if and when the board were to consider whether it were moved to a machine recount, I would like to be heard on that matter.
Understood.
I also have some questions about process of the recount. And at the appropriate time, I'd like to make a request to be heard on those matters. I have some questions about process.
It's been noted, Mr. Burr.
Thank you. So this board and the public in Michigan have heard a lot of speeches and public statements about my client's petition. 95% of what you have heard is legally irrelevant because my client has complied with all the legal requirements necessary for a valid petition. Indeed, she has filed a form of petition that opposing counsel have often filed and have never objected to on behalf of their clients. My client did, as hundreds of candidates before her, without objection, timely filed a recount petition on November 28th. And now, in a desperate attempt to avoid a hand recount of the votes in the presidential election that will assure all the voters of Michigan of the accuracy and integrity of the election and that all votes will be counted, Donald Trump and Trump for President have filed specious objections to the petition. And I'd like to work my way through those objections and indicate why they are meritless. The objections go on at some length about this question of whether Dr. Stein is aggrieved. And if you listen very closely to the comments this morning, the one key word in the statute was never mentioned by the attorneys for Mr. Trump, and that is the word alleged. That is the key word in this statute. It means what it says, and it's also been interpreted by the courts of this state, decisions. The right to a recount to the top two candidates, a candidate that may have, arguably, theoretically, mathematically, whatever the standard they could conjure up, a chance of turning the election results around. That's not what the statute says. And it's never been interpreted that way. So that's the statutory language. And the courts of our state have been very clear that we are to interpret statutory language according to its plain meaning and not read into it the issues that the objectors have raised. In addition to that, we believe the controlling case here is a case called Kennedy versus State Board of Canvassers. In that case, there were attempts to inject substantive requirements into the requirement that a recount petition allege fraud or mistake. And the court, over 30 years ago, rejected that, saying that, as we have argued here, you don't construe these statutes to impose those kind of requirements, that all the petition requires is an allegation. And the Kennedy case relied upon the same construction of this language that we're relying upon here this morning. You only need allege, in that case, fraud or mistake. The word allege also modifies aggrieved. So you only need to allege that you are aggrieved. As this board too painfully knows, the legislature tells you when it wants to make determinations and inquire into the substance of a petition. The legislature has directed you to do that in the situation of recall petitions. And I know that's been a painful, difficult experience for this board, one that you do not relish. That language does not appear in this statute. The legislature has not authorized you to conduct any inquiry into whether someone's aggrieved at all or what the standard may be. The objectors go on page after page after page of legal standards. The legislature has not authorized you to investigate or hold anybody to those standards. The statutory language is also very clear that the Board of Canvassers, when it receives a petition, shall cause a recount. It's mandatory language, and that is the venture upon which you are embarked. Let me deal with a couple of the allegations that I heard the first time this morning and be glad to respond. First, there were allegations made about what was said by me on behalf of my client on Monday. And we distributed copies of the statement and read into the record. Key sentence: the bases for these assertions include but are not limited to the following allegations. We were making allegations on Monday. And we were making those allegations as part of our effort to urge this board to hold a hand recount. And this board so authorized unanimously on a bipartisan basis on Monday. Once that happened, it was not necessary for us to file affidavits as part of our petition. Our mission had been accomplished. This board held to its traditional policy of conducting manual recounts when recounts are requested. I would also indicate that if anybody is interested in what those affidavits might have looked like, they can look at the State of Wisconsin website where similar affidavits were submitted. But they were not necessary here once this board decided to authorize a hand recount. So we filed the standard form of recount petition that has been filed hundreds of times without a problem. Finally, I must respond on this point to a lot of the language, a lot of the attacks that have been thrown at my client as to baseless allegations of election irregularities, etc. And I would remind everybody that the original source of the claim that this election was rigged is Mr. Trump. It's Mr. Trump. And a manual recount will also dispel his allegations that somehow this election was rigged and lacks integrity. So the first objection as to the standards or imposing standards, meeting standards for aggrieved is really meritless. Quickly on the Electoral College objection, it's very clear under the statute this board only has jurisdiction over, quote, objections to the recount petition. If Mr. Trump has concerns about the recount process and so forth, which is what the Electoral College issue addresses, this is not the forum for those objections. This board only has jurisdiction over the form of the petition. And finally, the alleged factual basis, speculative basis for that objection is purely that. It's speculative. There has not been a statewide Michigan recount since the 1950s. And no one can accurately predict that it can't be finished by December 12th or whatever the deadline is for finishing it. My client has every confidence in the Bureau of Elections, its director, and the clerks of this state that they will be able to finish this recount on time. Finally, as to recognizes notarial acts outside of Michigan, MCL 565.262. And so there really is no merit to this quibble over the notary requirement. The objections cite no authority that would indicate that the sworn statement submitted by Dr. Stein is inadequate. Finally, and alternatively, should the board find merit in that objection, it's also very clear that electors who are pledged to Dr. Stein would have standing to file as well. Under Michigan law, when voters cast a vote for any presidential candidate, they're not actually voting for the presidential candidate, they're voting for the slate of electors. Those electors are candidates. This board just a few days ago signed certificates of election for a set of electors. So clearly, the losing candidates, those who are not elected as electors, would be aggrieved, and they're entitled to file a recount petition, and several of them joined this petition. So they clearly have standing, even if this quibble over the notary requirement, the sworn statement requirement, are found to have merit. Finally, before I take questions, we've heard a number of allegations that we are the cause of delay here. That one of the requirements of the petition is that you file a complete list of all the precincts and absentee voter boards that you ask for a recount. We asked for that list. I'm not blaming anybody, but that list was not available to us until Tuesday. That list is also the basis for calculating the fee. And so there have been numerous press reports over several weeks, and people ask, well, why did the fee keep shifting? Well, the fee didn't shift at all. It hadn't been finally calculated because the final number of precincts and absentee voter boards had not been determined. The fee could not be calculated. Once we had that information on Tuesday, we were prepared to file, and we filed on Wednesday. So there was no delay here attributable to my client. With that, I'd be glad to answer questions.
Well, I actually have a statement or an observation. You had indicated that we approved a hand recount on Monday. I made the motion, and there was nothing in the motion about a hand recount. So I don't believe you're correct. If I read the motion, and it's contained in our minutes, it said the board authorized the staff of the Bureau of Elections to represent the board at any recount votes cast at the November 8, 2016 general election. And in fact, we hadn't even been requested to have a recount yet. So how could have we, in fact, approved a manual recount?
So is that a statement or a question?
Well, the last, you can take it as you will.
The policy of this board, as indicated by Mr. Thomas on Monday, and the policy of the department has been that there would be a manual recount if a recount is requested.
I would also say that is what we discussed on Monday was a hand recount.
I made the motion, and I did not put it in the motion.
I believe that our chairperson asked specifically if the hand recount needed to be part of the motion and was told no, because that's the standard policy of this board.
Well, I made the motion, and I did not put it in the motion.
Now that we're on this topic, Chris, did we ever find a motion from this board in the past saying the policy is hand recount?
And do we have a policy, written policy?
The last motion I found that the board has actually made was in 1992 to hand count optical scan ballots. We have never done a machine recount of optical scan ballots. This board has consistently been advised prior to motions that were made on Monday, and they were advised on Monday that we do hand counts and that was where we were planning to go. Objections were raised to that. Motion was passed. I mean, what we did Monday is what we've done each time. We've said, generally, you authorize us to basically implement your policies. This particular board I'm not aware has ever voted on the specific question of whether we do hand or machine recounts. In this town to date,
Was it passing a motion affecting one recount at that time? Or was it a broad new policy for the Board of Canvassers?
It was not in that vein, no. It was prior to, as you recall, that year there were several legislative recounts across the state. They were a combination of old lever machines, punch cards, and optical scan. So there were actual motions made for both punch card and a separate motion for optical scan that they be done by hand. Those were the earlier days of optical scan. They were just coming onto the scene. For those that were there, Grand Traverse County had used it in that general election for the first time, and it was a bit of a problem. So we have consistently informed you that we believe that's your policy, and we've consistently done recounts by hand. The Bureau of Elections has never done an optical scan recount by machine.
Is there any further questions for Mr. Brewer?
Yes, I have a couple of more. Mark, do you think that have you ever represented a candidate and that only received 1% of the vote prior to this and filed a petition for recount?
No.
And would any of the candidates, we had 7 write-in candidates, if they got a vote, they would then be a candidate with a vote. Could they come before this body and ask for a recount?
That's what the legislature has authorized, Ms. Barrow. I mean, that's what the language of the statute says.
So every time we have an election, we could have one person with a write-in, register as a write-in candidate, and if they have deep enough pockets, they can throw our entire election system into chaos. We allow this today.
I don't agree with your last statement. It's not chaos. Recounts, you all have participated in them. I've represented clients at them and been there in other capacities. They are not chaos. Mm-hmm. They are well organized in this state. Mr. Thomas and his staff.
They're well organized and take a lot of time.
But they're an important part of assuring the voters that the machinery, literally the machinery of democracy, works. And they're an important safeguard in that regard, and that's why recounts have been permitted and should be permitted under our laws.
Okay. Then also, I just had a question. You had indicated in your response that this board does not have authority over the recount process, right?
No, what I was indicating was I think that was as to the Electoral College objection.
Okay, but you said
that was a question of process. That particular question was a question of process that this board does not have jurisdiction over. The Electoral College Act.
It is an argument relating to the ensuing recount process. Thus, we have no jurisdiction.
I apologize if I was not as precise as I should have been. That was a response to the argument that this board has authority to do anything with an objection based on the Electoral College Act. My apologies.
You indicated that we have a mandatory duty to go forward and conduct a recount upon the filing of a petition and deposit, that we shall investigate the facts set forth in the petition. I keep looking at this petition, and it is very short, and I expected a lot more after you came before us on Monday, alleging many things. What are the facts in this petition that we are supposed to investigate? The facts.
The facts are the allegations of fraud and mistake.
The allegations.
Yes.
Oh.
We have satisfied, my client has satisfied the statutory requirements, and under Kennedy and many other cases.
So the facts in this are the allegations of?
Fraud or mistake, which is the statutory language, which is what hundreds of petitions prior to this have said, without objection and without halting the process. Why is a different standard now being imposed on my client that has been imposed on every other candidate, no matter their background, no matter their party, independent, non-party, who've asked for a recount in this state?
Yeah. I just see no facts. I see no facts here.
Well, but I would argue that it's the allegations. And
no, that's what he's arguing.
Well, and I'm arguing it too. We have candidates out there I'm going to be specific. Mr. Trump spent a whole lot of time on the election trail talking about fraudulent elections and rigged elections, and just last Sunday tweeted about millions of illegal voters. We have created a whole system of allegations about fraudulent elections and illegal voters, and that in and of itself is reason enough for me to do a hand recount where people can see the ballots and how they were marked, and whether it's Ms. Stein or one of her electors or Donald Trump or anyone else. I think the allegation of fraud and mistake in this election has been hugely overrated, frankly. I don't think we're going to find much, but I think it is part of the process. Ms. Stein alleged mistakes or fraud. That's enough to trigger a recount. She has paid her fee. I don't think as a board we have the ability to say we're not going to do a recount.
I was just asking, what are the facts? What are the facts? I was so surprised when I got this petition and there is nothing there. Julie, on Monday, we had all of these things. This is what happened. Things happened in Arizona. Things happened in Illinois. I don't know why you're not recalled, but I know you're not her attorney in those states. But if all of these things happen in those states, why aren't they requesting a recall there or recount there? There were all of these things that were set forward, and I assume that those were some of the things we'd be investigating, right? Because those were the only things. This was all we had before we made our motion to go ahead and give this over to the staff and all of that. And then we get a sentence. I just find it hard to believe. I know that Mark is always very precise in his filings.
I believe that it is the recount itself that will turn up if there are problems or not. That's where we will see.
Right.
I think that our job as the Board of Canvassers, again, is if someone alleges impropriety and pays the fee, they get a recount. It's part of the process. I don't see how we object to that. I do have a question that I'd like to actually direct to staff, and it's about this electoral college deadline. We've heard now from 3 attorneys out here who have different opinions on this. I guess I'd like one more opinion on what that deadline means, how much it hangs over us. I'd like the Attorney General's opinion on that from our staff.
Good morning. Good morning, Madam Chair and members of the board. The one thing I would like to say is, on Monday, you did certify the electors. So Michigan has complied with the, at least the Electoral Count Act in that respect. And so now it's up to the governor, obviously, to complete the process. And that process, as I understand it, is now underway. So I think the question that's being posed about the December 13th deadline has to do with if there are electors that are then presented after as a result of the recount process.